Testing. 1, 2, 3, testing. Can you hear me now? Can you hear me? All right. You got it? Everybody here? And everybody here. This is a hearing after all. All right. Sorry. Thank you for coming. We're going to get started in about 4 minutes, but before we do, I want to see exactly who is here. We had lots of people sign up to speak, and I want to see who on that list is here and who's not. And I'll just go through the list here, and if you are here to speak, I'll ask you to let us know. First of all, on the list, we have Attorney Pepper Crutcher. I see him in the back. Pepper is here. Represented from the Attorney General's office. Who is that? Is our AG's office represented here? Not yet. Okay. Department of Public Safety. Here. Yes, sir. All right. Thank you. What's your name, sir?
Brad Vincent.
Brad Vincent. Mr. Clyde Goodwin.
Here.
All right. Mary Townsend.
Here.
Reverend Jeremy Tobin.
Here.
Mr. Thomas Ray Floyd.
Here.
Bishop Joseph Latino.
Here.
Greg Patin.
Here.
Abigail Peterson.
Okay.
Maria. Mason.
Here.
Here. All right. Mr. Bear Atwood.
Here.
Bill Chandler.
Here.
Patricia Ice.
She's outside and will be in. And I want to say she's representing the American Immigration Lawyers Association, Mid-South Chapter, and I'll be on.
Dan Batson.
Here.
Right. Rims Barber.
He's outside, he'll be here.
All right. Dr. Rodney Hunt. And I understand, Dr. Hunt, you may want to split your time or share your time with Mr. Moran, Harry Moran. Ingrid Cruz. Paul Mosley.
Sir, he couldn't be here. I'm Joe Andy Hill, and I'll be speaking to him.
Okay, what's your name, sir?
Joe Andy Hill.
What's that last name?
H-E-L-C-O-N.
Okay. H-E-L-C-O-N. Got it. Okay, great. Ken Winter.
Here.
Bill Myers. Barry Walker.
Here.
Israel Martinez.
Here.
Mike Sayers.
Here.
Tony McElroy.
Back here.
Steve Rushing.
Here.
Robin McCrory.
Here.
Janice Lane.
Here.
Cheryl Bland. Gloria Bowles.
Here.
Clarence Bowles.
Here.
Kimberly Moore. Okay. Consuela Moore. Dean Cotton. Clyde McGee.
Here.
Donald Campbell.
Here.
Kolo Rashid. Kolo Rashid. John Palmer. Okay, I understand the AG's folks are here. And then we have some additional requests. We had Mary McLaurin.
Here.
We had Rita Anderson.
Here.
And we had Laura Minow Rochelle.
Here.
All right, I think that's everyone.
Mr. Chairman.
Yes,
Can you put Bill Marcy down there?
we'll put you at the end of the list, Bill. We sure will.
I've been there before, sir.
And I want to welcome everyone to this hearing on immigration enforcement in the state of Mississippi. It is time for us to begin. I want to begin by welcoming everyone here. And are there still people on the outside who have not made it in? Are there still people out there?
Yes.
Okay. Let's see if we can't get them in here to stand around the table.
There's about 80 or 90 people there.
80 or 90 people. Well, then that won't work.
there's not.
Okay. So we're going to have to proceed like this. Today's hearing is something that we talked about doing back in the session. You will recall. I want to give you some background as to the purpose of this hearing. We come here today as a Judiciary B Committee. We are tasked with the public of Mississippi to formulate policy in our state. I want to thank our committee assistant who's helped with this process, Ms. Carolyn Bales. Mr. Pro Tem, there's a seat. I thought there was a seat. Is there a seat for you, Mr. Pro Tem?
I'm fine, Mr. Chairman.
Okay, thank you.
I think someone has that seat.
All right.
I'm fine.
All right. I want to thank our committee assistant, Carolyn Bales, and the committee counsel, Jimbo Richardson, for assisting with this. The purpose of this hearing is to simply find facts, determine facts on the subject of immigration in Mississippi. Recently, in June 2012, the Supreme Court of the United States issued a ruling that defined what the authority of the states is and with respect to immigration enforcement, what the states can do, what they cannot do. And we're going to consider these issues today. And by way of background, I would remind everyone that we have current law on the books, the Mississippi Employment Protection Act of 2008. The E-Verify law, as it's been called, is on the books. It was passed in 2008. We're going to hear an update on that as well. And then we had some proposed legislation last year that did not survive the process. I think there's a seat over here, Mr. Horan, okay. And welcome to the committee. Of course, we had some legislation last year that did not make it through the full process. And we're going to consider, are there ways to improve the law that we do have? Or do we need to do anything at all? Do we need to have another bill? Do we need to work on the Employment Protection Act? And what's our authority with this respect? A few procedural rules that we will enforce for this hearing. First and foremost, we will maintain order and decorum. We're here to hear everyone's position on this. We have a diverse group of participants, and all people here are deserving of respect and a hearing on this subject. We are to maintain respect for both sides. We have literally both sides and probably every angle that can be imagined represented here today. And there should be no outbursts or interruptions during any person's presentation. The Sergeant at Arms, I'll ask the Sergeant at Arms and the Capitol Police to assist to maintain order in this regard. I am advised we have a maximum amount of people who can fit in this room. I want to apologize that it is not our regular room. Room 113, we had planned to have the hearing in, was in renovations, and they did not complete the renovations in time, so we are in the Ways and Means room here. First of all, we're going to hear a somewhat detailed legal summary of the Supreme Court constitutional decision from June 2012. And we will allow some time for questions and answers from the committee to that presenter. We will then hear from the AG's office on the current status of the Employment Protection Act of 2008 and enforcement of it. And then we will hear from the Department of Public Safety on the issue of the process of drug interdictions and federal enforcement within our borders, how that process is working presently. Following those presentations, we're going to open the floor. We're going to go down the list of the public participants in this meeting. We're going to, due to the large number of participants, we're going to have to invoke the House rules, and we'll limit participation to no more than 5 minutes per participant, but upon request of a member of the House, we will have an additional 2 minutes for each presenter for a total of 7 minutes. And if a person can fit questions and answers in that additional 2 minutes, that will be fine. If you can summarize your remarks in less time, if things begin to get repetitive, I would urge you to do so. You'll be notified when there's 1 minute remaining so as to conclude your remarks. And our timekeeper on that's going to be Committee Secretary, Faithful Committee Secretary Jason White. Finally, I would ask you to note that this hearing is being recorded, and we're going to maintain a record of it, so it'll be important for all of our participants to speak directly into the microphone on the table at the opposite side of the room. Again, on behalf of the House Judiciary B Committee, we welcome you to this hearing, and we appreciate your interest and participation. With these ground rules in place, I'll ask Attorney Pepper Crutcher to begin with his summary of the Arizona Supreme Court decision.
Mr. Chairman, do you have a preference whether I stand or sit? I think I might afford a better target if I was standing.
That's all right. That suits your preference, gentlemen. Welcome.
Thank you very much. Ladies and gentlemen, Bob Pepper Crutcher, this is a question I'd be asking if I were you. I'm an employer's lawyer. I've been an employer's lawyer for a bit over 30 years.
Don't get allowed.
I had to learn immigration law, not because I ever intended to be an immigration lawyer, but simply because my clients demanded that I know some of it in order to advise them. So I'm not a lawyer who handles visa applications. I'm not a lawyer who represents immigrants. I represent employers and advise them about how to comply with immigration law. And for that reason, I had to study the Supreme Court June 25th opinion in some detail in order to answer their questions, and I've written some about it as you may have read. Let me start by summarizing what it did, and then I'll say what it didn't and how I think it applies to your tasks. First, the opinion of the Supreme Court in the case of Arizona versus the United States was a sweeping preemption decision, leaving states with very little that they can do to regulate immigration. Basically, it says that a state may continue to petition employer licenses and some sort of similar transactions on federal immigration law compliance. And secondly, despite the federal government's contrary enforcement policy, a state statute is not facially unconstitutional simply because it permits a law enforcement officer to detain a stopped subject for just long enough to check that subject's immigration status. However, that statute may turn out to be unconstitutional as applied. Now, in detail, here's what the Supreme Court did. It considered 4 sections of Arizona law, commonly called SB 1070, also known as the Support Our Law Enforcement and Safe Neighborhoods Act. Section 3 of that law made an immigrant's failure to register as an alien with the federal government a misdemeanor offense. That section was stricken as preempted by federal law. Section 5C of Bill 1070 criminalized the seeking or performance of work by an unauthorized alien. That section also was stricken as preempted by federal law. Section 6 of Senate Bill 1070 authorized an immigrant's arrest upon reasonable suspicion of his unlawful status. That section also was stricken as preempted by federal law. The only one of the 4 challenged sections of this Arizona law that survived preemption analysis, and that solely on facial unconstitutionally analysis, was Section 2B, which authorized and required Arizona law enforcement officers who were stopping someone for some other lawful reason to inquire about their immigration status and to ask the federal government for information about the subject's immigration status. Now, this case has been confused, sadly, with the prior case of Whiting, Chamber of Commerce versus Whiting. Those of you who read that, many of the lawyers in this room, that was a case about whether Arizona could punish employers who knowingly hired illegal aliens by taking away their licenses. And that same statute said, and if you use E-Verify, which we require you to do, that's an affirmative defense to your liability under the statute. The Supreme Court, in a very split opinion, with 3 justices going the other way, affirmed the Ninth Circuit and said, yes, that is a lawful exercise of state licensing powers. Now, a little bit about the basic law of preemption. Federal law under the Constitution of the United States overrules state law in 3 situations. One, where federal law expressly preempts state law. That is, the federal statute says you can't do this to the state. Secondly, where the federal law has so pervasively regulated a field that it is reasonably implied. It's like fencing off your property and putting a no trespassing sign along the fence. States can't do anything within our fence. That's called field preemption. The third sort of preemption is called conflict preemption. That's where federal law has regulated in some particular balanced way some subject matter, and a court concludes that to allow states to regulate in their own interest and perhaps differently would conflict with federal law and disrupt the enforcement scheme. And that's another kind of implied preemption. So you've got 3 kinds of preemption at work in this analysis. And the core section you need to be worried about is how the Supreme Court interpreted Section 1324A-H2 of the Immigration Reform Law. Here's what it said. This is a section of law that says that states may not regulate employers except with regard to state licenses and similar laws. Now, as Justice Scalia said in dissent, that could be read to say states have complete freedom to regulate the immigrants. or anybody else. But that's not how the Supreme Court read that section. The Supreme Court read that section to say there's nothing else that's left for states to do other than to regulate employers and recruiters and referrers for a fee with regard to immigration compliance by and through state licensing and similar laws. Clearly, business licenses are state licenses. Professional licenses, probably also state licenses. Exactly the outer boundary of what is a state licensing law is not clear. It wasn't resolved by the Supreme Court in this decision. Now, as you confront the problem you have of what is left to you to do after the Arizona decision, you need to understand that the Arizona decision was a throwback to the preemption analysis of the 1970s. In very recent years, Justice Roberts, you remember who wrote the opinion in the Affordable Care Act case, had earned a reputation for being very deferential in legislatures. That's what got him on the Supreme Court, his idea of judicial modesty. As we don't overturn statutes, if there's anything we can do to avoid it. You saw him doing that in the NFIB versus Sebelius Affordable Care Act case. This analysis is at the other end of preemption. It's the kind of thing you saw from the Berger court, it's the kind of thing you saw from the early Rehnquist court, where the majority opinion says the federal government has done something important, the federal government has done something complicated, and we're going to imply for that the states are to keep out of this area, except to the extent the federal government in a statute expressly says you have something left to do. And that's the section I quoted for. Now, Justice Scalia in dissent, by the way I agree with him, says it just boggles the mind to say that a state conflicts with and interferes with federal law when the law being interfered with is the decision of the executive not to enforce federal law. Nevertheless, that is what the Supreme Court ruled in this case. And so my analysis of Arizona versus the United States is that all the state of Mississippi has left that it can do is what's preserved to it by the anti-preemption carve-out of 1324H2, which is you can regulate employers, recruiters, and referrers for a fee through state licensing and similar laws. I think I've used my 5 minutes, Mr. Chairman.
Thank you. Well, I'll request 2 more. If you could summarize the public safety aspect, the other aspect beyond the employer provision.
Well, now we get into a territory where the Supreme Court did not expressly rule. The reason is, and what I think saves Section 2B of the Arizona law is, and I think, by the way, this may be why John Roberts voted this way, to save Section 2B, because we know there are 3 votes to kill it. They said there is not an adequate evidentiary record in this case to say that a law enforcement officer will necessarily violate the Constitution of the United States or conflict with federal law when he stops an immigrant and inquires about immigration status. The government actually argued that Arizona law enforcement officers shouldn't be allowed to even ask the government for information. And Justice Kennedy said, wait a minute, I don't know how there's a constitutional prescription against asking the government for information. I certainly don't see it in the statute. We can't imply the confirmation in the Constitution. So, if a law enforcement officer is engaged in an otherwise lawful stop of someone who has reason to believe may be unauthorized in the United States, he has the authority to continue that stop for just long enough to check. Now, you can see where this is going to get into constitutional problem. How long is long enough to check? Is that 5 minutes more than you would have stopped him anyway? Is it 10 minutes? Is it a half hour? Is it 2 hours? Is it 40 hours? How long is too long? What if you pretend you have a basis that you don't actually have under some other law in order to cover for your desire to stop the alien to check his immigration status? You're probably in legal trouble there too. In other words, there's a line that's going to be drawn by later litigation. It wasn't drawn in this case as to how long is too long to hold somebody solely to check immigration status.
So, this is a question. To summarize, would it be correct to say that the Supreme Court did not overturn the authority of the state to regulate licensing and condition licensing on compliance with federal immigration law, That's
Yes.
part one.
Yes.
And they did not overrule the right of the state to make that check, status check, in the course of an otherwise lawful stop, detention, or arrest.
Yes, but it's important on that second point to understand that this was just a facial constitutional analysis, which means is there no way the statute can be understood as constitutional? And the Supreme Court said because the statute might be applied constitutionally, we can't strike down Section 2B, but we're not telling you that we won't strike down the first case that comes to us because of how it actually was applied.
Okay. Any questions about the committee? Okay. Thank you, Attorney Crutcher. We appreciate your time and your presentation today. Thank you for being with us. Next on the agenda, we have the Attorney General's office to give us an update on the E-Verify law that is on the books. Hey, Blake B., I'll recognize you for that purpose.
Okay. Thank you. You can go down.
Go down and speak in the mic. As I said, this hearing is being recorded, and so if you'll just speak into the mic, that'll be helpful.
Thank you, Mr. Chairman. I'm Blake B. I'm a Special Assistant Attorney General and the Attorney General's Office Legislative Liaison. The person who can answer our questions is Deputy Attorney General Mike Lamford to speak to the Assistant Coordinator.
Thank you. Is there any way we can adjust the volume on that? Anyone?
I can put it closer to my mouth.
That's great. Okay, you adjust it yourself. All right. Proceed, Mr. Lansford. Thank you.
I don't have anything particular to add to what Mr. Crutcher said. It's rather thorough. And, our law, the E-Verify law, is still on the books, and it does provide for licensure revocation for violation of the E-Verify law. And that is still available to local governmental entities, state agencies, and whoever else. The statute also provided for criminal penalties for folks who employed or accepted or were employed in violation of the Act. That part has been effectively struck down by the Arizona case.
Thank you. Have there been any instances of actual requests or complaints or to enforce the E-Verify law? It's been on the books since, I think, 08. Can you give
Our office has received no complaints.
None at all?
That's correct.
And is it correct to say that since July 1 of last year, all employers in the state are supposed to be complying with that E-Verify check? That's my understanding of the law.
I believe that is correct also.
All right. Any questions by the committee? Representative Taylor.
I've got one question. Who enforces this?
The statute sort of disperses enforcement authority over it. It says the Department of Employment and Security, the State Tax Commission, the Secretary of State, the Department of Human Services, and the Attorney General shall have the authority to seek penalties under this section and to bring charges for non-compliance against any employer or employee. However, like I said, the criminal penalties provided have been overruled.
And our law does not have any civil penalties, does it?
Just no civil, what you might call civil fine or fee, just the revocation or potential for revocation of licenses and permits and contracts.
So what you're saying is since no complaints have been filed, then it's more reactive than proactive.
Sure.
And your employers that hire these illegals are not going to call you and say, I didn't do an E-Verify form, are they?
I don't know. I would assume not.
All right, thank you.
Any other questions by the committee? Okay. Thank you for that report. We appreciate the Attorney General sending y'all over, and thank him for us. We appreciate that.
Thank you, sir.
Thank you. So we'll move now to the Department of Public Safety, and the reason that we requested the Department of Public Safety come and give us an update is to address that second prong that Attorney Crutcher was speaking about, that the lawful stop, detention, or arrest. And if you will, Officer Vincent, what's your title?
I'm Staff Sergeant Brad Vincent. I'm the Director of the Criminal Addiction Unit for Highway Patrol.
Great. Staff Sergeant Vincent, welcome to the committee. And we'll just ask you to give us, if you don't mind, sort of a summary of these stop, detention, or arrest situations that you're aware of as they occur, and particularly when unlawful immigration is involved.
5 minutes is nowhere near what I would need to explain how complicated the organized crimes that are controlled by, predominantly because of where we are here from Mexico, and the use of illegal immigrants in the furtherance of their criminal enterprise. It's a $1 billion-a-year industry. It's a lure of easy money. Our borders are obviously very porous, so the illegal immigrants are very commonly and very often recruited to move. Mainly the main drugs we see are marijuana, cocaine, and methamphetamine, whether it's produced here in our country or whether it's produced and transported across borders from these organized units in Mexico. On a typical traffic stop, whenever I have somebody that I have that's undocumented, if I have somebody that has no ID whatsoever, they're obviously not from the country, they speak little to no English, and they have no identification whatsoever, or oftentimes they'll present you with a Mexican consulate card or some type of visa that they'll give as a border crosser, things of that nature, but they're not licensed to drive. We have access to the HIDA, the High Intensity Drug Trafficking Area, is the acronym HIDA, from the Gulf Coast in Mississippi that supports law enforcement in our investigation of mainly drugs, drug courier activity, but other types of crimes too. And it's not always just drugs. There's a lot of other types of crimes that these organizations are funding and running. When I run somebody by name and birthday through HIDA, they can check the, I call it the INS system. I'm not sure exactly which database it is. I don't work down there, but they check the database to see if they are a documented alien. If they're not a documented alien, I can only assume that they are not from here. But the problem we have with this is because they are undocumented, they're masters at producing fake IDs. And they're also masters at producing documents, Social Security cards, birth certificates, and things they need to obtain what appears to be a legitimate ID, but it's not them. They're very transient, and they move around a lot, so it's very difficult for us roadside when we do stop somebody, and not just from a traffic stop, I'm talking from a drug interdiction, once we've identified that there's a crime going on, to figure out who they are. Often there are a lot of instances, just recently now, we have support from the immigration, from the ICE, Homeland Security. They have mobile vans with deep fingerprint machines now that run wirelessly. If they've ever been deported before as an illegal alien for a crime or for whatever the reason, it'll show up. And a lot of times they're using another name when they come back into the country. I'm not going to say the majority, but very, very often what we see is the use of illegal immigrants because they're the one that takes the fall. Most of the time, not all the time, but a lot of the time, when they're convicted of these crimes, instead of being incarcerated, a lot of times they're deported back. Instead of putting them in our jails and running up our taxpayers' expenses keeping the jail here, because they are illegal, a lot of times they're convicted and they're transported back across the border and deported. As porous as the borders are, a lot of them are right back across. You know, the ones that understand the system and how it works can be back in days. I've even had a roadside with ones that were documented that were criminal aliens who identified on the side of the road that had their families with them maybe at the time. I've listened to them say, "Don't worry, baby, I'll be back in 10 days." So it is an issue with public safety with the drug is concerned. But it's not just that. There's an awful lot of identity theft that's going on as well.
I was going to ask you, what if you had to put a percentage to the type of crime? Would you say most of it is drugs or other types of crime?
The huge majority that I see where illegal immigrants are concerned is drug courier activity. They're typically what we call mules. That's when we stop driving the car. They don't even know what's in the car. They don't put it in the car. They just get paid to drive from point A to point B. It's typically what we see.
And where are they typically coming from?
It could be anywhere geographically because of where we are. Typically what we see, your major source cities are going to be El Paso, anything down around Brownsville, McAllen, in that area, Houston, and Dallas. We see them coming from Phoenix, Tucson, Los Angeles. Austin, Texas has become quite popular recently. But typically that's where we see these loads of drugs that we get coming from those areas.
Obviously, we could spend more time, but we do have a question from Representative Wooten, and I recognize her at this time.
I'm sorry, I didn't get your name.
Brad Vincent.
Officer Benson. Are you stationed here in Mississippi?
Yes, ma'am. I actually work here in the Jackson area.
Okay. How often is it, possibly within a monthly time period, that you make a stop for someone that you believe to be from across the border, and they actually have drugs on them?
About a ratio as far as the number of stops we make versus the number of seizures we make?
Right.
That's not going to be a high figure. It's not going to be anywhere close to, it wouldn't even be 10% because we stop a lot of cars. We make a lot of stops. The huge majority of the motoring public on I-20 is not criminal. The huge majority of them are legitimate. And we do stop all of them. Like I said, if I stop, if I stop 400 or 500 cars, I would say, I'm going to say, if I'm just guessing at a number here as best I can, I'm going to say between 600 and 700 stops, I'm going to have somebody transporting drugs. You may have two back-to-back, and I may have several seizures in a week, but I may go 3 or 4 months before I make a seizure, so it's not a real consistent.
Thank you.
Thank you. Representative Barrett.
Thank you, Mr. Chairman. Officer Vincent, you articulated a problem that you experience when you stop somebody and you detain them or arrest them, and then they end up being deported, and then they're back frequently in a very short period of time.
Yes.
What would you suggest that we as a Mississippi legislature do to try to address that problem?
Here in Mississippi, that's a difficult question for me to answer because the majority of the people I deal with aren't from Mississippi. If I had somebody here from DEA or Bureau of Narcotics that does long-term investigations concerning wiretaps and surveillance and things of that nature, where they could give you more specifically what's going on locally within our communities that have a high population of illegal aliens, there is, I'm not going to say a high degree, but there's definitely criminal activity in those areas and that they are involved in. And they know that because from time to time they'll have roundups and they'll serve warrants and things. From my standpoint, though, from what I do, the majority of these people are not from here. As long as the border's porous, there's nothing we can do here to stop them from coming back. They oftentimes, the most effective thing that we have is what ICE uses, which is their fingerprint machine, because once they're documented, once they're processed, and they're deported back to Mexico, they take their fingerprints. The technology is now roadside. In fact, the technology is near to being where I can take my iPhone and use my iPhone it was attached to a scanner to check somebody roadside myself. The technology's out there. It's new, but it's actually existing. There's pilot programs for it. That's the most accurate way for me to identify an illegal alien that has already been deported, that's now a criminal alien that's come back, because when they come back, they assume a new identity. And if you run that identity and they've never been arrested or deported before, under that name and under that birthday, if I don't have a fingerprint, I can't tell. If I run them through HIRA, it comes back no record found. You just got an undocumented alien. If there's no criminal history with it, there's no way that we could, we can't arrest or deport people just because they're here illegally. So it's really complicated. And in a short period of time, I'm doing my best to try to explain what my opinion is of what's going on.
Well, you're doing fine. I appreciate it. Are we giving you and your colleagues the tools that you need to do the best job you can do out on the highways?
I'm satisfied with for my position, for my department, the tools I have to do my job. As far as the training and equipment and things, it's just I'm just a small piece. I'm making contact. But what happens after I make contact involves the feds and what they do with it. We don't control how they operate or what they do, of course, but it's a lot bigger problem than even I believe that it really is. It's a multi-billion-dollar industry. We consume about 70% of the world's drugs here in this country. And the statistics have shown the majority of it's coming from across the border.
Thank you, Officer Benson. Thank you, Mr.
Frank,
Chairman.
let me, and we're running out of time, but I know this, we may have to actually have a separate follow-up meeting maybe later on in the year or even in session, and I'd like to get some of those other folks to your department that you mentioned, the wiretap folks that can come in and talk about the within our border, within Mississippi's borders. But I think we'll have one more question for Representative Horan. Recognize you.
Thank you, Mr. Chairman. Sergeant Benson, I want to ask you, I think that everyone on the committee appreciates the fact that you're probably being very conservative, for lack of a better word, to say that out of 600 or 700 stops, you may have 2 or 3 that result in someone that may be conducting themselves illegally, not only as an alien. Is that what?
I misunderstood the question. I thought resulting in some kind of felonious crime. Now, as far as identifying how many am I stopping that I'm identifying as illegal aliens, is way more than that.
Okay, that's. I wanted to make sure that I understood that. Let's say out of 1,000, I understand you don't have any documents in front of you. I would certainly would hold you to this in the future, but out of your experience or things that the things that come to your attention during the course of your employment with CIB, out of 1,000, what would you be your best estimate out of 1,000? How many of those traffic stops result in the identification of an illegal immigrant, not necessarily driving, but in the vehicle?
That's a different question from what I understood a while ago. And let me say this, if you understood how we work and what we're looking for, I could leave right now and I could go out there and in a short period of time, I could find you some illegal aliens. Not simply because they appear to be from Mexico. When we're looking for criminal behavior, there are things people do. I don't want to take it any more of your time. Criminals have to do the same things. They don't have to, but they typically do the same things. If you saw a truck going down the road and had a horse trailer in the back and had still some roping on the side, you would assume that was a cowboy. Illegal immigrants, when they're new in the country and they're leaving the border and they're going to North Carolina, Mississippi, wherever they're going to work and stuff, they typically operate the same way. You oftentimes see them in very old, beat-up cars with brand new registrations. And they'll be loaded down with stuff. They'll have everything that they picked up. Their clothes, their bedding, all their stuff, and in the process of moving. And they don't have any license. They're not documented. They've only been in the country a short time. And they're usually driving really slow. And oftentimes they're driving erratically because the vehicles are unsafe, or because when they get nervous and they see us, they look back to see if we're going to pull out and run off the road. So if I use my techniques for identifying what is nervous or criminal behavior, your numbers would be real high, way more than 50% if I applied those techniques, and that's what I was looking for.
But I guess what I'm saying is that I'm trying to get my hands around the situation that we're here to address here today. Would you say that out of 1,000 that if you had...
I would say 80%.
8 out of 10 would be...
8 out of 10 if that was what I was identifying. Now, random stops as a whole, just random stops,
if you're doing interdiction, I understand that you may be a situation your numbers would be higher. But what I'm looking for is something that we're going to be struggling with as far as what the Arizona versus U.S. case and other things that we're going to be faced with in the future. Generally, for probable cause purposes and stop purposes, out of the 1,000, how many of those 1,000 stops would result not necessarily in illegal immigrants conducting criminal activity, but then illegal immigrants? Do you understand the difference? I know you understand.
I understand your difference, but it's not that easy to answer because again it goes back to who I'm stopping, and it's not the same every day. Right. And I've never kept a record of it or anything like that. If I'm stopping vehicles that are predominantly from these areas, from these source cities and stuff that I'm looking for, I'm going to say probably maybe 5 out of 10. Okay. Half of them are going to have illegal aliens in it. Right. Now, if I'm making traffic stops from vehicles registered in areas that don't have a high population of illegal immigrants, it wouldn't be near as many.
Let's take that number 5 out of 10 to be something that your best estimate. out of those 5 out of 10, how many of those 5 are conducting illegal activity, other than the fact that they're immigrants in the United States illegally? There's a difference between
Right, and I'm assuming you mean a major crime, such as drug trafficking or identity fraud or something of that nature?
or even being in the country after being deported, which is a crime. How many of that 50% are being...
It's going to be less than 10%
Okay.
of those. So we're using 1 out of 10. It's going to be less than 10% of those are going to actually be involved in a major crime.
Okay.
The majority of the illegal aliens I stop, based on my roadside investigation and stuff, are not here to commit crimes. It's not the majority of them.
Thank you very much.
Thank you. Staff Sergeant Benson, we really appreciate your time and coming over here and giving us this information. I do hope to follow up with you and the department later on with these other questions. And maybe, I don't know if it's possible, but maybe if we could begin to get some statistics on this, that would probably be helpful. If you could, I know it's hard to put a pencil to it, but maybe in the future we can get some statistical information on those kinds of questions that were asked.
I'll be prepared to give some numbers.
Thank you. We appreciate you. Thank you. All right, Mr. Clyde Goodwin, and we're going to these beginning at with Mr. Goodwin. We have members of the public who have requested to speak, and I recognize you at this time, Mr. Goodwin. If you can give us your remarks.
Well, first of all, I want to thank you all for holding this forum. I appreciate it because it's been needed. I would just my main thing here today is the E-Verify law is not working. I disagree with what the Attorney General's office said a while ago. There's nobody in the state of Mississippi you can call that'll even take your phone call if you've got anybody to report, any company or anybody hiring illegal. I have actually called the Attorney General's office before, and they have told me that it's a federal problem. It's not a state problem. And I know of, and I'm not going to mention the companies, but I could. I know of a company that closed down that had several illegals working there. They went and a friend of mine, a very good friend of mine that I'm associated quite closely, worked at that particular company. They went to another company not too far from there and got a job. He hadn't been there long, and these same illegals, and this was after July of last year, these same illegals turned up there working where he had left before. They come down there and got a job. He's thinking that maybe they went through some form through Florida that had companies in Florida, and they hired them down there and they just transferred them in here to get around it. I don't know, but the E-Verify is not working in the state of Mississippi. For one thing, there's nobody to call, nobody to report it to. I think they ought to make the law stronger, not only take their license, and I don't care if they hire 100 people. They need to understand they need to follow the law of Mississippi. There's too many people that's skirt the law. The law is not being enforced federally. It's not. And another thing, I couldn't understand him a while ago where he said that it was getting under this ruling whether we could stop them from getting driver's license or not. If they're going to give driver's license, which I hope they never do, and I hope that they make that very strict if they don't have to, that they put something on there saying, giving a color identity or something, saying this is not a citizen. Because I'm telling you, you can take that driver's license and go to any voting state county courthouse, register to vote. You don't have to have anything but your personal driver's license to register to vote. I'm telling you, if they give these people driver's license, they're going to be in the polling places, and we do not need them voting. And like I say, I ain't got a lot to talk about. I just want something done about this situation. And I'm going to be honest with you. I am so upset. I've waited 8 years for Billy McCoy. I don't know if you want to mention names or not. I waited 8 years, and then I'm thinking, man, we finally gonna get it. And boom, we ain't got it done. So I'm very upset. Anyway, thank you for your time, and I appreciate you.
We thank you. Where are you from, Mr. Goodwin?
I'm from DePauw County.
All right. Welcome to your state capitol. Thank you for coming. Appreciate it. We have Ms. Mary Townsend of El Pueblo. And I'll just tell the committee this. We had individuals call from different organizations, and because we had so many, we had to limit each organization to one representative. And Ms. Mary Townsend is representing El Pueblo today. Welcome.
Good afternoon. Thank you. Actually, El Pueblo is a program of Seashore Mission, which is charitable and social justice outreach of the United Methodist Church on the Mississippi Gulf Coast. We have outreach to the poor, to the homeless, and to the immigrant community. El Pueblo is a vital component of that ministry, and there we provide immigration and legal services and represent clients before USCIS, which used to be INS, and the immigration judge in New Orleans. I understand the purpose of this hearing to be to assess the effect of immigration on the state with an eye toward bringing up a bill similar to HB 488 in the next session. But today I'd like to focus on the potential human toll of bills like this. In our immigration practice, we see a lot of unauthorized aliens who nevertheless have a legal remedy under the Immigration and Nationality Act. That is to say, they qualify under some provision of the INA to receive lawful status. In order to do that, they need an attorney or an accredited representative to help them navigate this very complex system, provide the proper evidence, fill out the right forms, pay the right fees, and wait for a final decision by USCIS. And during all that time, they might remain in unlawful status until a final decision is made. Usually, it would be very difficult for a law enforcement officer who encountered such a person to be able to determine that that person had a case pending, or even though that person is now in some unlawful status, that the person has a legal remedy that they're in process of petitioning for. Many of our clients have been victims of violent crimes, including domestic violence and human trafficking. Usually, it's very difficult for these individuals to go to the police for help because they're more afraid of being deported than they are of the victimization they've suffered. This is the very reason that Congress has provided several methods of relief, one of which is the U visa. One of the U visa's main purposes is to encourage the undocumented to cooperate with local law enforcement in the investigation and prosecution of violent crimes. The U visa has provided a real sense of security for these victims, letting them know that they can go to the police with confidence and without fear of deportation. Laws such as HB 488 and others like it would have the opposite effect, setting up local police as adversaries instead of as protectors of the community. I can give you an example of one of my clients. Juana's husband tried to kill her. They were both undocumented. She was afraid of the police. Her husband had a long history of physically and emotionally abusing her. And finally he tried to kill her, but by the grace of God, she escaped from him. She had a friend who tried to convince her to go to the police for help, but she was very afraid, and she almost didn't go to the police. Finally, her friend did convince her, took her to the police station, interpreted for her. Her husband was arrested, and with Juana's testimony, he was convicted and deported. As a result of her cooperation with the police, Juana now has a U visa. She has lawful status. However, it took 8 months from the time she filed her application until she was granted her U visa, and it took several months before that to prepare the application to be filed. So for over a year, she was in the process of gaining lawful status, but there was nothing, she had no kind of identification, she had nothing from immigration to show that she had any lawful status, because she didn't. Any police officer who had encountered her during that time would not have been able to tell what her situation was. And other women like Juana never go to the police because they're afraid of having their immigration status questioned and being reported and ultimately deported. Even now with U-Visa, everybody doesn't know about this. But just think for a moment of the human suffering we're talking about if women and men who are abused suddenly see the police as adversaries instead of protectors. These are people who are degraded, who are humiliated, often in front of their children, who are beaten, kicked, slammed into walls and furniture, pushed out of cars, burned, threatened with the loss of their children, and sometimes with the loss of their own lives. These are people who live in constant fear and who believe there is no one to whom they can turn for help, not even the police. We do this work as people of faith, called by God to love one another. So I'd like to comment on the bill from a faith perspective. Most people in Mississippi find faith to be very important to them. Over 59% of our people said in a recent Gallup poll that they attend church services at least weekly. Many Mississippians, myself included, would say that their faith is the most important thing in their lives. As people of faith, I think it's important that we reflect on what our faith traditions have to say about the immigration situation in our country. Virtually every national religious body in this country has spoken out in favor of some sort of comprehensive and just immigration reform that leads to some path for earning legal status for the 11 million undocumented who are presently here. That includes United Methodists, Catholics, Baptists, Lutherans, Episcopalians, evangelicals, practically every national body. Why? Why do all these Christian groups speak out in favor of these immigrants? Our commitment to a just immigration policy is based upon our faith. Throughout the Old Testament, God calls his people to take care of the most vulnerable among them, including the alien. Over and over, God calls upon his people to care for the widow, the orphan, and the alien. Jesus makes an even stronger statement. At the Last Supper, he tells us, "A new commandment I give you, love one another. As I have loved you, you must also love each other. By this, everyone will know you are my disciples, that you love one another." So the God of all creation calls us to welcome the stranger, to do good to everyone in need. In Matthew 25, Jesus identifies himself directly with the poor, the marginalized, the stranger, and the prisoner. Indeed, he tells us very straightforwardly that our very salvation depends on how we relate to the most marginalized among us. To treat the alien with suspicion and anger, to hold on to our position of privilege by holding others down, reveals a deep misunderstanding of who God is and of the mission of Jesus Christ. By serving the poor and the immigrant, we are helping to build the kingdom of God. Everything we do for immigrants, we do for Jesus. And so in closing, I can only plead with you not to introduce or support any bill that will further victimize or marginalize our brothers and sisters in Christ. Bills that will force us to choose between obeying the laws of Mississippi and obeying the laws of God.
Thank you. Thank you, Ms. Townsend. We'll go to Reverend Jeremy Tobin. You're here?
I'm here.
All right. Yeah. Oh, you have a microphone. Yes, sir. Right ahead.
Can y'all hear me?
Yes, sir.
First of all, Mr. Chairman, it's an honor to be here, to be able to give testimony in this very important matter. In the 2 to 3 minutes allotted me to say why I am opposed to state legislation criminalizing undocumented immigrants and driving them out of Mississippi cannot do the topic justice. I will make some basic points. First, my religion teaches that people have a right to migrate and work to achieve better living conditions. Second, economic conditions in the home countries of these migrants drive them to migrate to achieve employment and security for their families. Third, the entire history of Latino migration into the United States has been a cooperative effort on the part of employers who need their labor and government who encourages and tolerates it. However, this partnership has resulted in exploitation of migrant labor. Fourth, arguments that immigrants are taking jobs from Americans are bogus. The economic disaster in Alabama as a result of its anti-immigrant law is but one example. Fifth, agriculture and lumber industries, as well as poultry industries, are dependent on migrant labor. American trade policies, notably NAFTA and CAFTA, and soon the trade agreement with Colombia, have had disastrous effects on farmers and small businesses, and specifically Mexico and Guatemala, driving them off their lands, seeking work elsewhere. These policies have exacerbated immigrants moving north for jobs. The so-called war on drugs has made things worse. Sealing borders does not solve any of this. Individual states are incompetent to address the causes of mass migration. They cannot usurp the role of the federal government. Only the federal government has the right to make and enforce immigration laws, period. Those whose businesses depend on immigrant labor will say that immigrant labor helps our economy. Both immigrant and native-born workers collaborate on the job and help employers. There are plans out there that indeed address solutions to the problems of undocumented immigrants. However, we are in a climate of xenophobia and racism that dehumanizes immigrant workers by labeling them illegal. Actions are illegal, people are not. Further, it makes rational assessment and planning impossible. Our history has abundantly demonstrated that with each new wave of immigrants, whatever the reasons they came here, have only enhanced and improved the quality of life for all Americans. Immigrants are a healthy contribution to our society. Many here will testify to that. I wish to point out that labeling them does nothing to solve the problems around undocumented labor. Laws reflect policy. If policy is based on exclusionism or fear of being overwhelmed by immigrants, the policy is flawed, not to say immoral. Immigrants have been pouring into the country from the beginning and made it what it is. What can change are policies that exploit workers for profit. What can change are visa quotas that reflect actual demand by employers. What can change are trade policies that drive people to migrate for work. What can change is a healthy appreciation of people of diverse national and linguistic backgrounds. What can change is education that encourages people to learn foreign languages and appreciate differences. Immigrants are not threatening Mississippi. They are contributing in every way possible. They are forced to live underground by a broken system that no state can fix. In fact, attempts by state to fix immigration only makes the problem worse. The only way forward is to pressure Congress to do its job. Thank you.
Thank you, Reverend Tobin. And at this time, I wish to say, and just for additional background, those who may not be aware, House Bill 48 that you passed on the House last year